Welcome to The Explainer. Today, we are tearing down the complexities of Indian corporate and securities law. I'm going to walk you through the definitive, hard-hitting legal framework that literally controls trillions of rupees in the Indian financial markets. Whether you're an investor, a legal pro, or you just want to understand the invisible forces governing these massive companies, listen closely. We're going to build up your absolute command of this subject. Let's dive right in.
Here's our game plan. First up, corporate foundations, how a company actually raises cash and structures its ownership. Then, we shift to market operations and the SCRIA to see how these securities trade. Third, market enforcement, which is exactly where SEBI drops the hammer. And finally, banking alternatives, zeroing in on NBFCs. Let's get moving.
All right, kicking things off with Section 1, Corporate Foundations, specifically raising capital, shares, and corporate debt. Now, before any company can go out and disrupt an industry, it needs capital, right? And the second you ask the public for money, you enter a highly regulated legal relationship. That entire relationship starts with an invitation.
And that invitation? That's the prospectus. The easiest way to memorize the four types is the hook DSAR. D stands for deemed prospectus. Basically, if a company sells through an issue house, that document is deemed a prospectus to close any legal loopholes. S is shelf prospectus. Banks file this once, and it's valid for a whole year of multiple issues. A is a bridge prospectus, which is the mandatory summary attached to every single application. And finally, R is the red herring prospectus. You see this in modern IPOs. It features a price band instead of a fixed price.
But listen, make absolutely no mistake, lying in that prospectus carries brutal consequences. The Companies Act splits this liability right down the middle. Under Section 34, criminal liability kicks in if the state decides to prosecute. The stakes here? Up to 10 years in prison for the directors. On the flip side, we have Section 35. That brings in civil liability, where a harmed investor can actually sue for financial compensation. So the state punishes under 34, and the investor gets their cash back under 35.
Which brings us to a massive 1889 ruling, Dairy v. Peak. Picture this. The directors of a tram company honestly believed they were going to get government permission to use steam-powered trams instead of horses. They actually put it in the prospectus. Well, they were wrong. Investors lost money and immediately sued for fraud. But the House of Lords laid down a monumental ruling here. They said an honest but careless belief is not fraud. To actually be fraudulent, a false statement has to be made knowingly or without belief in its truth or recklessly indifferent to whether it's true or false. Because these directors were genuinely, honestly wrong, they actually escaped the fraud charges.
But who actually has the right to sue? That's the punchline of our next landmark case, Peak v. Gurney. If you buy shares directly in the IPO, you relied on that prospectus. Make sense? But what if you buy those same shares months later on the secondary market from some other guy? The court firmly held that a prospectus is addressed specifically and only to original subscribers. The second those shares hit the open market, the prospectus has done its job. Secondary buyers have absolutely no legal standing to sue based on the original IPO prospectus.
Okay, so how does a modern IPO actually happen? It's a highly dynamic process we call book building. Step 1, the board hires a lead manager. Step 2, they file a massive draft red herring prospectus, the DRHP, directly with SEBI. Step 3, investors start bidding within a price band using ASBA. If you don't know, ASBA simply blocks the money right in your bank account. And finally, the company discovers the cutoff price based on actual real-world demand. Though keep in mind, if they don't hit 90% subscription, the whole shebang gets called off.
Now, let's say the company is already public and someone tries to pull off a hostile takeover. This is where SEBI versus Ajay Agarwal completely changes the game. Agarwal crossed the trigger threshold of share ownership but conveniently forgot to make a mandatory open offer to the public. Years went by. His argument? The delay meant he didn't have to do it anymore. Well, the Supreme Court completely crushed that argument. They ruled that SEBI's mandate to protect retail investors is absolute. It doesn't matter how much time passes, if you take control of a company, you have to give retail shareholders a fair exit opportunity. That obligation literally never dies.
So the shares are in play. How do they actually change hands? You've got to differentiate between transfer and transmission. Transfer is totally voluntary. You sell your shares, you fill out Form SH4, you pay the stamp duty. Simple. Transmission, on the other hand, is automatic by operation of law. Think of a shareholder passing away. The shares go to their legal heir without any transfer deed. And this brings up the brilliant Howard trading case. The Supreme Court ruled that transferring shares is really a two-stage process. When you just hand over the transfer deed, the buyer only gets what's called equitable title. But legal title, meaning the actual right to vote and get dividends directly, that only happens when the company officially registers the new name in their books.
Now, what exactly are you buying? Under Section 43, you're looking at two titans, equity shares and preference shares. Equity shareholders are the true, undisputed voting owners of the company. They take on the maximum risk, they get paid absolutely last, but they also take all the leftover upside. Preference shares, they sacrifice that voting power in exchange for priority. They get a fixed dividend first, and if the company goes under, they get their capital back first. And remember Section 55, all preference shares in India must be redeemable within 20 years. Irredeemable preference shares are strictly illegal.
What if the company just wants to borrow cash? They issue corporate debt, which we call debentures. But investors obviously want security, known as a charge. You really have to grasp the difference here. A fixed charge acts like a padlock on a specific, identifiable asset, say a factory. The company cannot sell that factory without the lender's key. A floating charge, however, hovers like a giant net over current assets, like warehouse inventory. The company is completely free to buy and sell inventory beneath that net, but the exact second they default, boom, the net drops. This is called crystallization, and it freezes whatever assets are sitting there at that exact moment.
Speaking of getting paid, what about your dividends? In the Bharat Commerce case, the Supreme Court was asked a great question. When does a dividend actually belong to you? The definitive ruling was clear. The exact second shareholders declare a dividend at the annual general meeting, it instantly becomes a legally enforceable debt. The company absolutely cannot take it back. In fact, if they don't pay you within 30 days, the directors are looking at up to 2 years in prison and having to pay 18% interest under Section 127. All right, let's shift gears to Section 2, Market Operations, focusing on the SCRA and the stock exchanges. We've raised the capital. Now, how do we legally regulate the wild trading of these securities on the secondary market? Enter the Securities Contracts Regulation Act of 1956, or the SCRA.
You see, before the SCRA, the markets were basically a wild west of rampant speculation. The SCRA laid down the law. It declared that all derivative and forward trading must happen exclusively on heavily monitored, SEBI-recognized stock exchanges. Trading forward contracts in the shadows? Totally illegal and void. It also forced the corporatization and demutualization of exchanges. In plain English, that means the brokers trading on the exchange could no longer be the owners running the exchange. It completely destroyed that massive conflict of interest.
Naturally, the brokers fought back. In the landmark BSE Brokers Forum case, brokers challenged SEBI's power to force this demutualization and cap their brokerage fees. The Supreme Court fully backed SEBI, upholding their massive power to regulate market intermediaries in the public interest. But SEBI isn't a dictator. In the MCX stock exchange case, SEBI actually tried to block a new exchange from trading equities, claiming they wanted to prevent market fragmentation. The Supreme Court stepped in there, ruling that while SEBI has wide discretion, it is absolutely bound by Article 14. It cannot act arbitrarily. Every regulatory condition SEBI imposes has to be objectively justified.
This brings us perfectly into Section 3, Market Enforcement, looking at SEBI as the market watchdog. Because let's face it, the rules mean absolutely nothing if you can't enforce them.
SEBI was given real statutory teeth back in 1992, right after the devastating Harshad Mehta scam. And it basically runs on 3 core mandates. 1. Regulatory, writing the rules and registering brokers. 2. Developmental, building up the market, like when they introduced UPI for IPOs. And 3. Protective. This is the fiercest mandate, actively guarding investors against fraud, price rigging, and insider trading.
And when SEBI protects, it hits hard. Take SEBI v. Shriram Mutual Fund. A fund violated investment rules, and SEBI slapped them with a massive civil penalty. The fund argued, wait, we didn't do it on purpose. There was no guilty mind, no mens rea. The Supreme Court dropped a terrifyingly clear answer on them. They ruled that civil penalties under the SEBI Act are strict liability. Absolutely no mens rea is required. If you break the rule, you pay the fine. Period. It makes SEBI's enforcement lightning fast and incredibly effective.
And there is absolutely no area SEBI polices harder than insider trading. This violation occurs the exact moment someone trades while possessing unpublished price-sensitive information, or UPSI. Now, UPSI is any non-public info that, if released, would materially affect the share price. Think of a secret merger or hidden financial losses. Trading on it is an absolute fundamental betrayal of the open market.
Let's look at 2 titans of enforcement cases here. In Hindustan Lever, HLL bought shares of a sister company right before announcing a merger.
Their defense? They argued they paid a fair price to a major institution who didn't even complain. The tribunal didn't care at all. They ruled the prohibition is absolute. The moment you trade with UPSI, you're guilty. Your motive or the fairness of the price is completely irrelevant. Now compare that to the rocky trading case involving the Satyam fraud. Here, connected entities engaged in circular trading to essentially fake market volume. SEBI punished them using purely objective data patterns. The court validated this, proving SEBI can infer market manipulation purely through statistical surveillance. They don't even need a signed confession.
Let's pivot smoothly to our final pillar, Section 4, Banking Alternatives. We're looking at NBFCs and depositor protection. Because you really cannot talk about Indian finance without discussing the massive shadow banking sector, the NBFCs.
Non-banking financial companies fund the high-risk ventures that traditional banks just will not touch. We're talking commercial trucks, rural microfinance, gold loans, but you absolutely must understand the hard legal line drawn between them. Banks take demand deposits, meaning you can withdraw your money anytime. NBFCs, they can only take term deposits for fixed periods. Also, bank deposits are legally insured by DICGC up to 5 lakhs. NBFC deposits have zero insurance. If they collapse, your money could just burn. And while banks are part of the payment system, NBFCs can't even issue checks. So yes, they offer high yields, but they carry incredibly high risk.
Because of that exact risk, the Reserve Bank of India keeps NBFCs on a very tight leash. In the monumental RBI v. Peerless case, a massive non-banking company challenged the RBI's strict rules. They claimed the rules violated their constitutional right to do business. The Supreme Court completely shut them down. They cemented the law right then and there. The RBI's duty to protect millions of retail depositors is paramount. The RBI's directions are legally binding and utterly supersede any corporation's claim to absolute business freedom. So, from the very first IPO prospectus to the heavy hand of the RBI, this entire legal matrix exists to solve one central tension. And that leaves us with a really powerful, high-stakes question to ponder. As these capital markets evolve with faster tech and wilder derivatives, how do we perfectly balance aggressive market innovation with the ultimate uncompromising protection of the retail investor? Think about that as you digest this framework. Thank you for joining me on this explainer. Keep learning, stay focused, and I'll catch you next time.